of an Escalade on 29 August 2015, a Saturday morning, at approximately 11:03 a.m. I believe it was on the eastbound I-10 near 19th Avenue.
Correct.
Okay. At times, refer to that shooting as shooting number 1, shooting A, or the Escalade shooting.
Yes.
You understand that?
Yes.
Okay. The second shooting that we'll be talking about occurred also Saturday, 29 August 2015, 11:05, 11:09, or thereabout, of a motor coach, a bus, as that vehicle was westbound on the I-10 at 43rd Avenue. And in this hearing, I may refer to that as the bus incident, shooting 2, or shooting B.
Yes.
The third shooting is an incident that occurred Saturday, 29 August 2015 at approximately 10:15 p.m. when a Kia was eastbound on I-10 near what we call the mini stack.
Yes.
And we may refer to that as the Kia shooting, shooting 3, shooting C as in Charlie.
Yes.
No water.
Yes. Give me some right now. There's nothing there.
What are we doing?
Thank you. Thank you.
And then lastly, there was a fourth shooting of a BMW Petro.
Yes.
Now, we'll get into this in some more detail, but your affidavit states that the victim, the driver of the BMW, reported that it occurred on Sunday night, 30 August 2015, between 9:45 p.m. and 10:15 p.m.
Correct.
Okay. And we may call that the BMW shooting, shooting 4, or shooting D as in Delta.
Yes.
Okay. And so I understand that shooting was assigned a report number that ends in 964.
It was.
Detective, with regard to the shooting of the Escalade, shooting number 1, 2 bullet fragments were recovered by the Department of Public Safety, correct?
Correct.
And it's those fragments that were later analyzed by the crime lab.
Correct.
Now, with regard to the second shooting, that of the bus, a bullet was recovered from a seat back.
Yes.
With regard to the Kia, several fragments were recovered from the interior of the passenger door. Is that correct?
Front and rear passenger doors, yes.
Now, with regard to the BMW shooting, the fourth shooting, detectives became aware of that on Thursday, September 3rd, 2015.
Correct.
Now, looking at your affidavit, and I'll call for the purposes of this record, there's a section that begins, facts supporting the affidavit, probable cause.
Mm-hmm.
And
Yes.
thank you. We're going to call that page 1. So on the following page beyond that, page 2, there's a notation that on August 31, 2015, Detective Baraldi, B-A-R-O-L-D-Y, requested bullets and bullet fragments be submitted to the crime lab under various report numbers.
Correct.
One of those is the 964 report number that's listed in the affidavit.
Correct.
Okay. And in fact, detectives did not even become aware of the shooting until Thursday, September 3rd, about 4 days later.
Correct. After our deposition the other day, I went back to our office and I read through the report. What I found is on August 31st, Detective Baraldi asked the crime lab to intercompare the first three report numbers from the first three shootings, shooting 1, 2, and 3. On September 3rd, the bullet fragments, or the bullet from shooting number 4, the BMW, was submitted to the lab. On September 4th is when the lab came back and said all 4 bullets were fired from the same weapon.
But at least as the affidavit reads, as it was submitted to Judge Granville, it reads that on August 31, the BMW bullet was submitted, even though detectives weren't even aware of that shooting at the time. At least as it reads.
It does read that, yes.
Very good. Now, your affidavit indicates that the crime lab said that all 4, we'll call them evidentiary projectiles, came from a high-point 9mm handgun.
Yes.
And that's because of the unique rifling or boring pattern that is distinctive to high-point 9mm.
Correct.
Now, let's go back a couple of days. You learned in your investigation, and we will get into it a little bit later, that Mr. Merritt pawned his gun, which is the subject of the action for which we are here today.
Correct.
Let's show you exhibit number 2, which is in evidence. And we determined that the gun was pawned at the Mo Money Pawn Shop on Sunday, 30 August 2015 at 5:31 p.m.
Correct.
All right. Now, you said that on September 4th, it was the crime lab that indicated that they all came from the same gun?
Correct.
Okay. After the BMW projectile was included?
Correct.
On September 3rd, the day before, however, detectives collected the bullet from the BMW.
Correct.
Okay. Let's talk a little bit about how that happened. Judge, for my edification, are we okay with the victim's name at this point? I know there's been a little bit of discussion in previous proceedings.
What, is there any problem with labeling it just to the vehicles?
I can avoid his last name as best I can. If I slip, I'm sorry.
Okay, well, you haven't answered my question. Is it okay just to label it towards the vehicles?
I could say the BMW driver.
Okay.
And Your Honor, I don't have a disagreement with that. The question is, since the search warrant was unsealed, I don't know if the victims' names were redacted, so I don't think that's necessary. But for this purposes, I do think if you can label it to the vehicles, that might be the best way to follow it.
With all due deference to the folks that are all here, rather than have somebody knocking on somebody's door this afternoon, why don't we just call them the driver of the particular vehicle?
Fair enough. Now, when the BMW driver was interviewed on September 3rd, he told detectives that the shooting occurred Sunday, 30 August 2015, between 9:45 and 10:15 p.m.
Correct.
And let's be clear, at least according to Exhibit 2, the gun was in pawn at the time that the BMW driver said the shooting occurred.
Correct.
The BMW driver had just come back from a trip from Chicago.
Yes.
He had put his car in a Sky Harbor garage Thursday morning at 5:55 a.m., according to records.
Correct.
He told detectives that he noticed nothing unusual on his way to the airport about the handling of his car.
Correct.
He said that the tire pressure was normal when he got back into the car.
Correct.
And he told detectives that he exited the west side of the airport towards the 10 and ultimately the 51.
And Your Honor, just in relation to this whole line of questioning, to the extent the witness knows what he said, and I don't think we're operating on the assumption that hearsay is excluded in this particular hearing, but to the extent that it's speculative and the detective does not know, I'd object to these questions.
Well, I believe with Mr. Detective Graff as the affiant, it's all based upon the information he knew at the time that he did the affidavit. So I'm premising everything on that.
And Judge, our argument would be the collective knowledge doctrine, that any knowledge that any member of the state had, the state and its agents, is imputable to the affiant to the extent that there's information that is excluded.
That's a legal argument, but let's first deal with the factual premise. If the detective doesn't know something, that's fine. And then the significance of that we can deal with separately. But just in terms of whether Detective Graff knew something at the time on June 27th of this year.
Okay. So, Detective, the first time that the BMW driver noticed a drop in tire pressure through his tire pressure monitoring system, or TPMS, was as he was going from the 10 onto the 51.
I believe he said that when he got in his vehicle and he started his car, the tire pressure monitoring system light came on and then turned off.
If I showed you a copy of the report from that interview, could you point the location out where it says that?
I can try. I don't know. I'm going off of my memory of what I recall from that. I wasn't involved in that interview.
Yes?
Is this his original interview or?
That's the September 3rd.
Okay. On the first page, the bottom line, it says, Hackbar stated his tire pressure sensors has shown his tire pressures were slightly lower than normal when he got into his vehicle, but that was not unusual due to the vehicle having been parked for several days.
Detective, you'll read things slower if you're going to read them again.
You want me to read it again?
No.
I'm sorry.
But any low pressure that he observed was normal after the car was sitting.
According to him, yes.
Detective, were you aware, or was any other DPS officer aware, to your knowledge, that the tire pressure monitoring system values that display when a car is turned on is the last value that was stored when the car was turned off?
I have no idea.
So we would need to speak to other witnesses to glean that information if it is so.
I would assume so, yes.
But with regard to that September 3rd interview, he said the first time that the yellow light came on the TPMS was as he was going from the 10 to the 51.
Correct.
And after interviewing the driver, detectives went to a BMW dealer.
Correct.
And that's when they recovered the bullet jacket and the lead cord.
Yes.
Detectives also spoke with BMW personnel.
Yes.
BMW personnel told detectives that the puncture of the tire that they observed would cause an immediate leak in air pressure.
I don't know if they said that to the detectives at the time or not. Again, I wasn't there at the dealership at that time. I wasn't even in the unit at the time.
Would you dispute that fact if I told you that's what was said per the reports?
Objection, speculation.
No. Right. He can answer that question.
Would you dispute that fact?
If it's in their report, I wouldn't dispute it, no.
Would you dispute the fact that the technician told your fellow detectives that the TPMS warning lights would have activated within 1 mile of the tire being punctured?
If it's in their report, I would not dispute that at all.
Are you generally aware of the BMW driver's area of residence?
I believe it's in Northeast Phoenix, Paradise Valley area. Ballparkish.
Good enough for today. Detectives noted the mileage of the car when it came in for service to BMW.
Okay.
And let me just clarify. The driver said it happened Sunday night, the 30th. He took it in for service to the dealership the next day, which was Monday, the 31st.
Okay.
Any disagreement on that point?
No disagreement.
And this is Thursday, September 3rd of the same week that this is all happening, where the driver is interviewed and the BMW people are.
Correct.
Do you recall that the mileage of the vehicle, based on the victim's residence, the distance from the airport, that was actually all consistent and suggestive of the tire being shot on Sunday night, as the victim had indicated?
I honestly don't even recall that. I didn't pay much attention to the mileage on the car.
Okay. Are you aware that the state received, through a court order, copies of the service records from the BMW in the context of the criminal case, which in fact showed the mileage as being suggestive of the shooting occurring on Sunday night at the time that the gun was in pawn?
I was aware that they got service records from the BMW, but I'm unaware that they are suggestive of the shooting occurring at any particular time, since the car is equipped with run-flat tires. I don't know how you can reach the conclusion of which day that vehicle was shot if the vehicle will not have any suffered performance issues as a result of the tire being flat.
Well, you're aware that run-flat tires work for 50 miles at 50 miles per hour.
I am not a tire expert. I don't know how long they will work for.
Are you aware that a tire expert report was provided to the state which showed that the wear on the tire based on the run-flat operation was consistent with the distance between the airport to the victim's home to the BMW dealership?
I was aware that there was an expert report, yes.
Okay, and that it stated that the run-flat caused wear and tear to the tire that was consistent for being driven less than 50 miles, which would be consistent also with the victim's suggestion that it occurred on Sunday night.
Again, I didn't read the tire expert's report because I was not the case agent, but I'm not going to dispute if that's what you were saying is in the report. I won't dispute that fact.
Okay. And by the way, we talked about Exhibit 2, the pawn slip, which I'm showing you again.
Yes.
You made no mention of the gun being in pawn in the affidavit that you provided to the court.
Correct.
Would you agree that at face value, this is exculpatory with regard to the shooting of the BMW as related by the victim? It calls for a yes or no, please.
Objection.
No, if you can answer it, you may.
Is it yes or no, sir?
If you can't answer it as yes or no, tell them you can't answer it as yes or no.
I can't answer that as a yes or no.
Okay. Would you agree that, and we'll get to this, that the crime log says that Mr. Merritt's gun was responsible for the shooting?
Yes.
Would you agree that the BMW driver said that it happened Sunday night, August 30th at 9:45 p.m. or thereabout?
Yes.
Would you agree that the pawn slip shows that the gun was in pawn at the time?
Yes.
And based on that, would you agree that with respect to the victim's contention, the pawn slip is exculpatory?
Based off that argument, yes.
And it was not included in the affidavit?
No.
Now, as we move forward in the investigation, I believe you got assigned September 5th.
September 5th is when I transferred to the unit, yes.
And on September 14th and 15th, you contacted various pawn shops looking for high point 9mm.
Yes.
And as part of your process of contacting the pawn shops, you used a pawn common spelling database, correct?
Correct.
And this, for the benefit of the court, is a database of all items that are pawned containing serial numbers, really to log, the property and make sure we're not having stolen property being pawned.
Correct.
And that database showed you that Mr. Merritt's gun was in pawn at the Mo Money pawn shop.
Yes.
And that's how you got to Mo Money.
Yes.
And in fact, not only did it show you that it was a Mo Money, but it showed you, based on the database, that it had been in pawn since Sunday, 30 August 2015 at 5:31 p.m.
Yes.
So when you went to the pawn shop on September 17th, you already had records to show that the gun was in pawn.
Correct.
You didn't provide that in the affidavit either.
I mentioned in the affidavit that we have a list of pawn shops that have loaned money for firearms matching the make and caliber of the weapon identified by the crime lab.
You did not mention in your affidavit that before even seizing the gun, that you had information from a law enforcement database that indicated that the gun was already in pawn as of as of Sunday, August 30th at 5:31.
No.
Now, after you acquired that gun, it made its way to the crime lab on September 17, 2015, correct?
Correct.
And that's when the crime lab started testing Mr. Merritt's gun, and I believe 8 other guns?
7 others.
7 others, total 8 guns. And this was a priority for the crime lab to get done, correct?
Correct.
This is something they had orders, as you understood, to rush and get done because of the nature of the investigation.
It was ordered that they have whatever overtime was available that they needed to get the investigation completed.
Sure.
Yes.
This was their priority.
Yes.
The next morning at 8:08 a.m., you were awoken by a phone call from a criminalist.
I was.
And he told you that Merritt's gun was a definitive ballistic match to the evidence that was recovered from the shootings.
Correct.
When we say definitive ballistic match, I believe you previously indicated that you interpret that to be a 100% confidence.
Yes.
That there's no other gun in the world that it could come from.
Yes.
Did you tell the criminalist that Mr. Merritt's gun was in pawn at the time?
No.
So on the 18th, you found out that information, and it was later in the day into the evening when you actually executed a search warrant at the pawn shop to memorialize the formal seizure of the gun.
Correct.
And that was before Mr. Merritt was arrested.
It was.
And that's when you came into possession of exhibit number 2.
Correct.
Did you tell anyone that as of 6:35 p.m. you had impounded evidence that showed that the gun was in pawn at the time of the BMW shooting?
After we were done executing the search warrants, I brought it back, showed it to the case agent. When they looked at the date and time stamp on the pawn slip, compared to the physical evidence that we had, we determined that the driver of the BMW had to be incorrect in his timeline.
Okay, so because the pawn slip shows that the gun was in pawn for the BMW shooting, the Department of Public Safety's position was that the driver must be wrong.
The physical evidence shows that the driver was wrong, yes.
My question was, because of the criminalist report, the Department of Public Safety took the position that the victim was wrong about when the shooting occurred.
Yes.
Okay. And when we talk about, I'm going to back up, we talk about a definitive ballistic match. The fragments from A
Correct.
came from the high point, and this is all to a 100% confidence, correct?
As far as my understanding at that
Yes.
point, yes.
Okay. The bullet from B, the bus shooting, came from the high point.
Correct.
The bullet or fragments from C, the Kia shooting, came from the high point.
Correct.
And D as well?
Correct.
Okay. So A equals B equals C equals D. They're all from the same gun?
Correct.
To a 100% certainty?
As far as our knowledge, yes.
Okay. So I understand this.
Just ask questions, Mr. Lane.
Is it your understanding that the bullet from the BMW, oh, strike that, I'll come back to that. You realized on Monday morning, the 21st, as you spoke with your fellow detectives, that there was a problem insofar as the pawn slip showed that the gun was in pawn. Yet, there was a match by the crime lab.
On the 21st, where's...
Monday morning, if Friday is the 18th, 19th?
We didn't take any days off, so I'm going to assume it was the next day.
Okay, it was a Friday that you got the information from the crime lab about 8 in the morning.
Correct.
It was Friday night that you went to the pawn shop.
Correct.
It was after that Mr. Merritt was arrested at about 7 p.m., correct?
Correct.
And it was the following Monday, the 21st, or thereabout, where you were sitting in your cubicle with other detectives and you recognized, and you heard them discuss the fact that there was a problem insofar as the gun was in pawn at the time that the victim said there was a shooting.
When I mentioned that in our deposition, I said that the case agents were talking about it, and we were all kind of talking about it, and the timeline does not match up with the physical evidence.
Okay. And let me just be clear. Because there is a, as you understood it, a 100% confidence on the part of the crime lab, the victim has to be wrong.
Correct.
Now, let me throw the converse at you. You know where I'm going already.
Correct.
If the victim is right, the crime lab has to be wrong.
Correct.
So the decision was made at that point, Detective, to re-interview the victim of the BMW.
Mr. Lamb, time out. If I can go back, Detective, is it possible to segregate the shootings, or is it your position that if it was not this gun that did the fourth shooting, it was not this gun that did the first three shootings?
It's our position that even if we drop the BMW entirely from the warrant, the probable cause still stands for the other three shootings as being fired from that weapon.
Okay.
We can disinclude any individual shooting, and we still have the ballistic information to show that the bullets came from that gun.
So, Lamb.
Is it your testimony that the bullet from the Escalade, A, was fired from the same gun as the bullet in the bus shooting, B?
Yes.
The bullet from the Escalade was fired from the same gun as the bullet or bullets in C, the Kia?
Yes, with the caveat that these are all based on our crime lab results, yes.
The bullet or fragments from the Escalade was fired from the same gun to a scientific certainty as the BMW.
Correct.
The bullet from the bus, B, was fired from the same gun as C, the Kia.
Yes.
That the bullet from B, the bus, was fired from the same gun as D, the BMW.
Yes.
That the bullet or bullets from the Kia were fired from the same gun as the BMW.
Yes.
So essentially, A equals B equals C equals D.
Correct.
Well, let me follow that up. I won't expect that you know DNA, but when they make a sample, they'll split up the samples.
Correct.
The analysis that was done on the bullet that fired A, that was a different entity than what was studied for B. Is that correct?
From the understanding that I have from our crime lab is when they had all the bullets, they took shooting A, compared it to shooting B, compared it to shooting C, compared it to shooting D, and then B to all those and C to all those. And then when we actually got the firearm in, they did test fires with it and compared it to A on its own, B on its own, C on its own, and D on its own.
The ballistics, I would guess, would have used the same known bullet from what the known gun was from the pawn shop.
Correct.
However, while they would have matched it against the same known, they used different subject or suspect fragments to do the comparison against the known.
Correct.
Mr. Lamb.
And Detective, is it your belief and testimony that the confidence level for each of the matches that we just went through is a 100% confidence on each and every one?
From our crime lab, yes, absolutely.
Okay. So a decision was made to re-interview the BMW driver based on the issue with the gun being in pawn, at least according to Exhibit 2.
Correct.
And was the goal to clarify the timeline from the driver?
I'm assuming so. I didn't do the interview, and I wasn't the one that assigned the interviews out.
Was it the intent, to your knowledge, to change his timeline in any way?
No.
Okay. How come no other victim was re-interviewed except the BMW driver?
At that point in time, his was the issue that we had the timeline issue with, and the media pressure with the changing of timeline and the timeline not matching up. We wanted to clarify that point.
Explain to me what you mean by the media pressure causing you, meaning the Department of Public Safety, to do follow-up interviews.
We were going to do a follow-up interview anyway, but we were constantly getting questions asked about why the state is changing their timeline, and we've never laid out a timeline to begin with. But after we got the match and we saw that it was in the pawn shop at the time, they conducted an interview to clarify to make sure his timeline couldn't have been off. And I don't know if that was because of his TPMS was saying that the tire was low when he got in the car and started it up, or if it was to clarify his timeline to see if it changed at all. And as I mentioned in our deposition, a lot of times when we interview somebody, we'll ask them 2 or 3 times, dates and times that things happen, to make sure that their stories don't change and it's consistent.
Well, the driver was re-interviewed, was he not, on September 22nd?
He was.
The day before this case went to the grand jury?
I don't know what day we went to grand jury.
And the driver said pretty much the same thing as he had on September 3rd.
Correct.
He said he went to the airport and there were no problems. When he drove on the morning of Thursday, August 27th, there were no problems. Correct. He said that there was nothing unusual whatsoever about his ride to the airport.
Again, I didn't read that interview. If that was in his interview and in the report, then I would say yes.
He said in that second interview, yet again, that the first time that he had a sense that there was something wrong is after he had left the airport and he was going from the 10 to the 51.
Your Honor, to the extent he's asking the witness to confirm anything in the interview, he should provide him with a copy of the interview to confirm that, or ask him if he knew it at the time.
Mr. Lamb, well, the other thing, I believe you have a factual support for the argument that we have a victim who seemed sure of the timing of when his vehicle was hit and the pawn ticket. So if you have a different point, let's get to
I can blow through this. Detectives did ask him if it could have happened at another time.
Correct.
And he was resolute in the fact that there were no tire pressure, nothing issues getting to the airport at all.
Correct.
He also said, if you or do you recall that he said that there were no warning lights when he got to the airport, and it was only after he left that the lights came on?
I remember being told that he said that. I didn't read the actual interview.
How come your affidavit doesn't make any mention of this second interview and the victim's confirmation of his account?
Because the paragraph that I wrote with his date and time that he stated didn't change, so that information was consistent. It didn't need to be another paragraph written saying the same exact thing, and the physical evidence contradicts what he said.
But at the time you wrote this affidavit, you had a belief, detective, that he was wrong.
Correct.
And you didn't provide the court with additional information that showed that he was consistent in his multiple statements to law enforcement.
Objection asked and answered, Your Honor.
No, overruled.
I wrote in the warrant, in that paragraph, that he had the date and time that he stated, and that's a factual statement that he wrote. I didn't see the point of writing that paragraph a second time.
Would you agree that in the context of the pawn slip, that second statement can be viewed as exculpatory?
I agree with that.
Let me ask you, as a general proposition, you believe that the BMW driver was wrong?
Correct.
Because the crime lab is right?
Correct.
Do you have any other evidence to support the fact that he is wrong other than the crime lab's findings?
I don't know.
To your knowledge, does anyone of the Department of Public Safety have any other objective evidence or knowledge that would suggest that the driver is wrong?
Just the physical evidence, no.
So it's strictly the crime lab?
Correct.
In fact, that's the only evidence against Mr. Merritt is the ballistics, correct?
As far as I'm aware.
All right. So let's fast forward to April of 2016. Are you aware that the county attorney's office hired an independent expert, Luke Haag, H-A-A-G, to conduct ballistics testing as part of the criminal case against Mr. Merritt?
Yes.
And you made some reference to that in the affidavit, correct?
I did.
Have you reviewed his notes?
I read the summary of his investigation.
Are you aware that Mr. Haag visited the DPS crime lab and looked at the same specimens that the criminalist did in making the 100% definitive ballistic match back on September 18, 2015?
Give me 1 second.
Sure.
Mr. Haag did look at our crime lab's evidence.
Right. And in the affidavit, you summarized his conclusions as saying that the comparisons done by DPS, in his opinion, were insufficient to constitute an identification.
In his report, in the summary,
So I'm just asking what your
Yes.
affidavit says.
yes, I did.
Okay. You make no mention of the fact that Mr. Haag did independent testing of the weapon and the evidence projectiles.
No.
In fact, because you have read Mr. Haag's report, you would agree that he could not identify Mr. Merritt's gun as having been the one which fired the evidence projectiles.
He also said,
Sir, Mr. Vigil, I know will follow up with you. Just respectfully.
sorry, repeat the question again then?
Get a read back on that, please.
In fact, because you had read Mr. Haag's report, you would agree that he could not identify Mr. Merritt's gun as having been the one which fired the evidence projectiles.
Correct.
You did not include that in your report.
I put in there that it was insufficient to constitute an identification.
Did you write anything about Mr. Haag's report?
I put in there that he...
I'm sorry, about Mr. Haag's independent testing.
No.
And in fact, Mr. Haag wasn't even able to test the projectiles or the fragments from the Escalade because they were so badly damaged. Isn't that true?
I don't know.
Is that something that we would have to bring in Mr. Haag to have him testify and talk about?
I'm not a ballistics expert, so I'm assuming so, yes.
Okay. So because DPS found this to be a 100% ballistic match with regard to the Escalade, and Haag didn't even find it suitable for testing, he would be the one to come in and sit on that witness stand and talk to us.
Correct.
So in fact, tell me if this sounds correct with respect to Mr. Haag's full conclusion. The 4 evidence bullets could be neither excluded or identified as having been fired from the Hi-Point C9 pistol with the serial number at issue. Does that sound correct so far?
Yes.
And with regard to the visit to the crime lab, did it not say this? the areas demonstrated by Mr. Kalkowski on February 29th and illustrated in the notes packages in his various reports on these shooting incidents, in the opinion of this examiner, were insufficient to constitute an identification.
Yes.
So your affidavit really doesn't lay out the full scope of Mr. Haig's opinion, does it?
I felt when I read his affidavit that the insufficient to constitute an identification pretty much sums up that he is finding that there's insufficient evidence to constitute an identification. So that's what I wrote.
Well, he said that the DPS crime lab had insufficient evidence to form an identification based on their work. In other words, what DPS did was insufficient in his mind to constitute an identification.
Correct. It's insufficient to constitute an identification.
Right. But what you didn't include, and that was exculpatory, was the fact that he did his own testing, and that didn't show an identification either. That wasn't listed in the affidavit.
Objection, Your Honor. It's been asked and answered.
Next question.
To your knowledge, did Mr. Haig know that Mr. Merritt's gun was in pawn at the time of the BMW shooting?
I don't know if he did or not.
Is that something else we'd have to bring him in to testify about?
Absolutely.
Now, I'll ask the court to take judicial notice in the criminal case. There was a motion to dismiss on Friday, April 22nd.
Okay.
Okay. So about a week after prosecutors moved to dismiss, the Bureau of Alcohol, Tobacco, and Firearms did more testing on the weapon.
Correct.
Why did that happen if the case was already dismissed?
The chain of command decided to send the gun over to the ATF to have them check it.
So DPS wasn't happy with the county attorney's expert, so they wanted another opinion? Is that?
Objection, speculative.
Sustained.
So, according to your affidavit, ATF found insufficient marks of value for comparison.
Correct.
And do I understand that correctly as the evidence bullets had insufficient markings on them for forensic comparison and an identification or exclusion?
That's the way I took the report, yes.
Okay. Have you reviewed their notes?
I read the summary of their report as well.
Okay. Did they do independent testing?
I am unaware of what they did for testing.
Did they look at DPS's work?
I don't know. I wasn't there.
Would we need to bring in an ATF criminalist from Virginia who did this examination to show us what was or wasn't done?
Yes.
So there may be additional things that were done, but that aren't reflected in your affidavit.
Correct.
And an officer of the Department of Public Safety was present during the ATF examination.
Correct.
So, do I understand correctly that your view is that Mr. Haig is wrong and the crime lab is right? Your crime lab is right?
My personal view?
Well, I'm asking you based as the affiant in this case. If
Yes.
let me just restate it so we have a good record. Your testimony as the affiant in this case is DPS crime lab is right and Luke Haig is wrong.
When they retested the bullets.
I'm not there yet.
But we are there because I
Detective,
authored this.
respectfully,
You,
at the time Mr. Haig did his examination, there was only one round of testing done by DPS in September.
Correct.
So if Mr. Haig, if DPS was correct back in September, Mr. Haig had to be wrong in his assessment. The two cannot coexist.
That's false.
Mr. Haig disagreed with DPS in terms of an identification with regard to September.
Mr. Haig said that there were insufficient marks for comparison, but he did not exclude the weapon from being the weapon that fired it. Our crime lab said it was the gun.
If I showed you the conclusion of Mr. Haig, can you show me where he said there was insufficient marks based on his examination for an identification?
I believe the last sentence of that paragraph.
He said that DPS's areas that they utilized were insufficient for identification. Correct?
Correct.
And then he did his own independent testing, as we've talked about. So if ATF could not make an identification, was ATF wrong with respect to the original DPS findings back in September?
At that point in time, I had no idea.
Okay. So during the time that Mr. Hay was doing his analysis, are you aware that he simultaneously conducted a study concerning high point 9 millimeters?
I wasn't aware of it at the time. But I know there is a study. I didn't know when he authored it.
At the time of the affidavit, you were.
Correct.
And he actually did that concurrently with his work in the Merritt case on behalf of the county attorney's office.
Okay. I'll take your word for that. This is what we discussed the other day.
And are you aware that it was published on April 27th, 2016?
Yes.
And tell me if I got this right. High points do not, the lands and grooves within the barrel, they don't grip the bullet very well. It's kind of loose and it can wiggle around a little bit.
Correct.
And that can affect accuracy.
Absolutely.
That can affect the striations that are put on a projectile by the lands and grooves as well.
Correct.
And that's one of the things that Mr. Haig said when he made his findings, that the gun just doesn't grip the bullet enough to leave a discernible mark.
That's the understanding I have, yes.
Okay. So what Mr. Haig did was he used a .357 bullet and put it onto a 9 millimeter casing.
Correct.
A 9 millimeter is .355. This is 2/1000ths of an inch bigger.
Correct.
So it's 9 millimeters, .355. The .357 is 2/1000ths of an inch. Bigger in diameter. Do I have this right so far, Detective?
Ballpark, yes.
Okay.
I don't know the exacts. Again, I'm not an expert, so.
So it's a tighter squeeze, so to speak, and there's more striations on the bullet.
Correct. The bigger diameter makes it have better contact with every landing groove in the barrel.
And that's what DPS did in their testing in June of this year.
Correct.
Okay. So if you would, when you do a scientific comparison, you have a control and you have an unknown.
Correct.
You have test fires and you have evidence bullets.
Correct.
And with regard to the evidence bullets, the unknowns, Luke Haig and the ATF said that there was insufficient markings or striations to create the identification on the unknowns.
Correct.
And what DPS did was they amplified the markings on the test fires in the testing that they did.
With the .357 round?
That is correct.
They didn't amplify them. They were able to collect all of the striations from the barrel.
They got
because of the wider
more
barrel.
striations.
Correct.
So when you're amplifying the control, that doesn't affect the unknown, correct? The markings on the evidence bullet
Are
didn't
the same.
change.
Correct.
And DPS concluded, and this is exhibit or addenda B to your affidavit, that Mr. Merritt's gun was conclusively identified to the exclusion of all other guns in the world.
I believe his quote is, when compared to the 357 bullets that were fired from the item 4 high point pistol, serial number whatever, there were sufficient agreements of individual characteristics in the land impressions to conclusively identify them as having been fired from the high point pistol serial number to the exclusion of all other firearms.
Okay. So that's the only gun in the world that could make these markings, Mr.
Yes.
Merritt's gun. Okay. You're also aware that a tire expert was engaged by Mr. Merritt.
I am aware of that.
And are you aware that the tire expert opined that with regard to the BMW, the TPMS indicator would come on within 1 second of the bullet penetrating the sidewall?
I haven't read the tire expert's report. The only thing I can go off is what you showed me the other day, and what you showed me the other day, yes, that's what he said.
Okay. And that expert report actually was provided to the state at some point during the pendency of the criminal case.
Correct.
So there was also testing done, and if you're aware, are you aware that additional testing was done that showed that the puncture of the bullet made a contemporaneous gouge in the inside of the tread of the BMW tire?
Again, just based off of what you showed me the other day.
Okay, and that was, again...
I didn't know that before I wrote this warrant as well.
Okay, but other agents of the Department of Public Safety were aware of that?
I'm assuming so.
Okay. None of that was mentioned in your affidavit either?
No.
You would agree that the tire expert corroborates what the BMW driver said in terms of his account? And the timing, and what I mean by that is that the timing of the shooting was Sunday night, August 30, at about 9:45 p.m.
Your objection.
Sustained.
Does the tire report, to your knowledge, support the BMW driver's version of the events?
Objection. Speculative.
Sustained.
So I want to ask you this.
In 2 minutes.
My best. The Department of Public Safety has made 2 separate examinations that find that Mr. Merritt's gun, to a 100% certainty, was the gun that fired the bullets,
Yes.
notwithstanding the pulse.
Correct.
And your position as the affiant in this case is that the BMW driver was wrong in his first interview on September 3rd.
My understanding is, my opinion as the affiant in this warrant is that the BMW is wrong in both of his interviews at the time of occurrence.
Because for DPS to be right, he has to be wrong.
Your Honor, objection asked and answered a number of times.
Sustained.
Well, for DPS to be right, Mr. Haig also has to be wrong.
That's not true.
If DPS is right, then the ATF is wrong.
That's not true.
And if DPS is right, then the tire expert has to be wrong too.
That's not necessarily true either.
The only evidence... Now, the same DPS criminals who told you about the gun match also told you that
I'm not a tire expert. I don't know if the bullet was rolling around in the side of all of that tire for a couple hours before it fell through, or if it did not. I have no idea.
But the Department of Public Safety was provided with the tire expert report that showed that that was exactly the case.
I would agree that they were provided with that tire expert's report.
And would you agree that that fact is supportive of what the BMW driver said?
Objection.
Yes.
Speculative.
I don't.
Sustained.
So would it be fair to say that there's a number of pieces of potentially exculpatory information that you did not include in your affidavit?
The exculpatory information, according to you, that I did not include is the pawn slip. And the physical evidence doesn't support that as exculpatory evidence anyway, so it was not included.
So basically, everything you have for probable cause is based on the DPS crime lab, and everything else doesn't add up. All the other issues don't add up.
Everything else is based on the physical evidence that the bullet that was recovered out of that car was a ballistic match to the other 4 and his gun.
And for that to be right, everything else has to be wrong. True?
True.
I don't have any further questions at this time.
Behill, we'll have to resume this afternoon if you have questions.
Okay, Your Honor, my schedule is blocked after 2, so I won't be able to be here after 2 o'clock.
How much time do you think you need for your examination?
Not much at all, Your Honor. I can probably get it done within 5 to 10 minutes at the most.
Well, then let's do it at 1:15, and we'll be done by 2 o'clock. I know I have a settlement conference. If there's strangers here, don't panic. I'll be signing a warrant. We'll see everybody at 1:15. Thank you.
Thank you.
You have the...
I know you the name. Kalkowski. K-A-L.
Yeah, we are going to lock it.
Thanks.
You're going to stay set up. You're going to stay set up.